Protection Act was recently passed by the Senate and is now awaiting final approval from the Governor General. Once the Act takes effect, it will no doubt have an impact on the way in which personal data is processed by companies in Jamaica. Many companies will be required to ensure that they are processing personal data in a manner that is safe, secure, confidential, and otherwise in accordance with the Act. Personal data is defined under the Act as any information from which a living individual or an individual who has been deceased for not less than 30 years can be identified. Now, this would include a name, date of birth, email address, residential address, your social media handle, or even your voice. Now, the term processing is a very wide concept under the Act, and it includes the collection, the storing, the using, the disclosing, and the destruction of personal data. If you are the operator of a hotel, a spa, or a clothing company, and you collect the personal information of your customers, i.e. their name or email address, you'd be required to comply with the provisions under the Act. Now, there are two key parties identified under the Act: the data subject and the data controller. The data subject is defined as a named individual who is the subject of the personal data. So your customers, your clients, and your employees would all be regarded as a data subject under the Act. A data controller is defined as a person or public authority who determines the manner and the purpose in which personal data is processed. For example, a government institution or a financial institution who collects your personal data on a daily basis would be regarded as a data controller under the Act. Now, there are a number of rights granted to a data subject under the Act. Some of these rights include the right to be informed that your personal data is being processed, as well as the right to access the personal data. The data subject also has the right to prevent processing for the purposes of direct marketing, except in circumstances where the data subject has consented or is a customer of the data controller. There are also a number of obligations imposed upon a data controller under the Act. Firstly, a data controller is required to register with the relevant authority and to pay a registration fee. There are certain categories of data controller who will be required to appoint a data protection officer. These categories include public authorities, or a person who processes personal data on a large scale, or who processes sensitive personal data, such as your biometric data or any information regarding your health. Most importantly, a data controller is required to comply with certain international standards under the Act. These standards include ensuring that the data is processed in a fair and lawful manner, ensuring that the data is obtained only for a specific and lawful purpose, and that the data is not being processed in a manner incompatible with those purposes, as well as ensuring that the data is not transferred to a state or territory outside of Jamaica unless that state or territory provides for an adequate level of protection. There are certain circumstances in which a data controller would not be required to comply with certain provisions under the Act. These circumstances include where the data is being processed to safeguard national security, or where it is being processed to prevent or detect a crime, or where it's being processed for journalism or literary purposes, or if it's being processed for personal, family, or household affairs. Now, what are the legal implications for failing to comply with the provisions under the Act? Failure to comply would result in a company being liable to a fine up to 4% of its annual gross worldwide income. A director, manager, or secretary of a company who has consented to the non-compliance or has acted negligent in any way may also be held personally liable. A company may also be liable to pay compensation to any person who can prove that they have suffered some sort of damage as a result of the breach. Due to the significant fines and penalties a company may face, it is very important for companies to start implementing certain technical and organizational measures to avoid or minimize a risk of a breach. Some of these measures include obtaining the data subject's consent prior to collecting, storing, using, or destroying their personal data. Consent must be freely given and informed. The data subject must be provided with all the reasons why you will be collecting their personal data, as well as the manner in which their personal data will be processed. Companies should also implement a data protection policy which will govern the way in which personal data is processed by them. This policy must be easily accessible to both customers and employees, and both customers and employees must agree to be bound by the terms of this policy. The Act does provide for a 2-year transition period for companies to get their affairs in order and to take the necessary steps to become compliant. However, as you can see, the obligations imposed upon a data controller are quite burdensome and onerous, and so it is very important for companies to consult an attorney and get on board now.